Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 189, 123 of BNS Act 2023. Corresponding law is sections 141, 142, 143 of IPC. Unlawful assembly. Evidence proof that the assembly in question consisted of 5 or more persons. Important point, where of 5 persons convicted, it was found as regards 2 of them that there had been no common object. It was held that the conviction of the others could not be maintained, as there must have been 5 persons who had a common object before there could be an unlawful assembly and rioting. That the object of the persons so assembled within brackets, either at the time it became an assembly or during the time that it continued to be assembly brackets close, was any of the 5 objects mentioned in this section 189 of BNS as Act 2023.
Welcome. That such object was common to the persons assembled. To establish the common intention of an unlawful assembly, it is not necessary to prove that its members actually met and conspired to common an offence, but such an intention can be inferred from the circumstances of the case. In the case of a consented attack by 5 or more persons, it is a perfectly valid and reasonable inference that they all had a common intention. Where a crowd has dispersed without taking any action, the intention and common object of that crowd can only be inferred from the surrounding circumstances. The attitude and demeanor of the crowd itself is one of the points which must be taken into consideration. Important point. The opinion or the impression of a witness that it appeared to him from the conduct of a mob that they had appeared for an unlawful purpose is not admissible in evidence to prove the object of the assembly, although statements as to what he actually saw and heard are admissible. The essence of the offence is the common unlawful purpose, and the accused cannot be convicted if the common object proved is different from the common object in the charge, or for which he has been tried.
Important point. If the common object fails and the substantive charge is disbelieved, the accuser should be acquitted. It is not proper for an appellate court, while disbelieving the alleged common object of an unlawful assembly, to find disbelieving alleged common object of unlawful assembly, to find out a different common object regarding which the accused were never called upon to plead nor tried, and to affirm the conviction.
That the accused joined or continued in such assembly It is sufficient for the offence of rioting to be proved against an individual that the individual should remain in an unlawful assembly after he is aware that the assembly is unlawful.
That he did so intentionally. That he did so being aware of the above facts. In this section, the following evidence to prove these elements, the court may rely on various forms of evidence. One is witness testimony. Eyewitness accounts from victims, police, or bystanders can establish the presence of individuals and their intentions. Second one is video and photographic evidence. Visual records of the assembly can confirm the number of people and their actions. Third one is physical evidence. Any objects used or found at the scene can provide supporting evidence of the unlawful common object. Fourth one is circumstantial evidence. Evidence of prior threats, actions, or communications between the members of the assembly can be used to infer their common object.
Punishment section. Under the section 189 bracket 2 to 9 of BNS Act 2023, accused shall be punished with imprisonment of 6 months or 2 years, or with fine, or with both. Cognizable offence. Police arrest an accused without warrant. Some subsections of this section is bailable, which others are non-bailable and triable by magistrate. This video is purely theory. The Honorable Court decides each case on merits. Thank you.
Thank you.